Okay, hello everyone. Welcome to our latest installment of the Lunch and Learn program. Can you guys hear us okay? Online? Yep, thanks. Okay. So today's topic is going to be the Canadian Charter of Rights and Freedoms, section 24.1 and 24.2. For that, we have our very own Jane Harrington and Kevin Sneesby. Just to give you a little bit of background about them, Kevin got his law degree at the Louisiana State University, and Marcel third in France because he likes French food. Kevin spent 10 years in the USA and then 24 years in Canada. He was at legal aid for most of his career. He did do some time in private practice. He has had 2 cases that went to the US Supreme Court, although none to date that have gone to the Supreme Court of Canada. And then as far as Jane Harrington, Jane has again been with us for quite some time. She articled under Sandra Bracken, who's our Deputy Executive Director, back in the 2018-2019 articling year. She then took a position in Kenora at Legal Aid Ontario with Duty Council matters after her articles. She returned to Legal Aid Manitoba in 2020, just at the start of the pandemic, which is an unfortunate time for everyone. She worked at the Duty Council office initially during the pandemic and then moved to the Regency Youth office, where she has been ever since. So with that, I'm going to pass it over to you two, and I will be setting your PowerPoint up when necessary.
So I get to go first because I'm more boring. I have more boring topic 24.1. Try to keep you awake. So 24.1, let's talk about that. It seems kind of like it's a unicorn. You've heard about it. You've never seen one. It's not. It's more like red northern lights. You see it every 10 to 11 years. I can tell you in my case, well, in Canada in 24 years, I've had 3 of them and lost them. But the reality is it's going to become more important. We'll see in the near future in Winnipeg. You may have letters, McNeil letters, or you might be helping senior attorneys that receive McNeil letters on convictions by police officers in Winnipeg. And there could be issues there where, quite frankly, cases could be overturned by 24.1. So 24.1 is interesting. It's a little confusing. There's a lot of case law. There's not a lot of case law. But you need to have basic understanding. It's almost like we're kind of going to go through spot the issue, almost like law school. I have a list of charter cases you should rely on. It was attached to the email. If nothing else, I put 2 stars. I was going to put something else beside Brunel, and I'm going to mispronounce this, of course, again. Nasogalak. Those are Supreme Court cases and very useful. So just to let you know, any major case, you don't have to write down, okay? So let's start. This is 24.1, the arcane dark arts of the defense lawyer. And that's what we're going to start with. Let's start with the wording. Section 24.1 of the Canadian Charter of Rights and Freedoms says, as you know, anyone whose rights or freedoms is guaranteed by this charter have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy at the court as the court considers appropriate and just in the circumstances. Wow, the world is our oyster as defense lawyers, right? Not so fast. So basically what happens is this section applies to government authorities who act inconsistent with the charter. Okay, it's important to note that. Why? Because if you are challenging the constitutionality of a certain law or act, you need to do that under 52.1 of the Constitution Act. Okay? So let's just think about that for a second. If you have an issue where you're challenging the constitutionality of the law and act, but your main focus is the actions of the government, you should still file under Section 52.1 of the Constitution Act. You don't want to leave that door open. In other words, you're challenging the constitutionality of the act, sure, even though your main argument is law enforcement or the Crown did something wrong. Okay? So that's kind of a trap for the unwary. Just always look at whether or not you need to challenge the constitutionality of the specific provisions, okay? Then, remember the language said competent jurisdiction. So the thing about 24(1) is it's hard, and it's not as common. And Jane's going to talk to you about 24(2), which is mainly, if not exclusively almost, is the exclusion of evidence. 24(1) addresses all sorts of other remedies. If I'm talking loud, it's not because I'm drunk, it's just so you can hear me. And so 24(1), so when you're talking about a court of competent jurisdiction, think of it this way first, okay? There's lots of remedies. But first, it's got to be the trial court. It can't be the JJP. It can't be the judge at a preliminary inquiry. It's got to be at the trial court, okay? Second, if you want money for damages, it's got to be in KB. Because the provincial court and all the other courts, they don't have jurisdiction. But the other courts do have jurisdiction for court costs. So provincial court could award court costs, but for damages to your person, your mental health, psyche, or your property, I guess, I'm not sure how, but could all be brought, but it has to be in King's Bench. The other thing is too, is you can also bring a tort claim and a 24(1) claim as long as you're not double dipping. Am I going too fast? Everything good? Okay. So basically the courts have taken the approach that 24(1) is forward-looking, it's cautious, it's a remedy to prevent violations from continuing or being brought up, and it's not supposed to go beyond the specific need. In other words, it's supposed to be fairly targeted. And that's R versus Babos, Babos, and that case is listed. The most dramatic remedy, and maybe why I lost, is all my 24(1)s have been for mistrials or stays, which is tough. Okay, so they say it's reserved for only the clearest of cases. It has to be really bad, and it has to be really clear. And I thought it was 3 times, and I lost. So just to let you know. Now, I'm just going to talk about R versus Edwards, that EDWARDS, and R versus Belnavis, BELNAVIS. Both Supreme Court cases, both deal with 24(2), so I'm not going to talk about it too much. I'm talking about the exciting topic of standing, where we all fell asleep in law school procedure. It's so boring and so important in this type of case. So you kind of have to know what you're doing here, okay? So first to know is, like, let's just talk about Edwards for a second, right? Ties that his girlfriend's apartment, and cops come in and search it. No expectation of privacy. Sorry, you're going to jail. Next one is Belnavis. It's a car, right? Belnavis is a passenger. They search it. No expectation of privacy. Have a nice day. That's basically what happened in those cases. The reason I'm raising them is the charter applications to exclude evidence under 24(2), the standing is basically the same as 24(1). Now, I say it's basically the same. And again, I'm going to say not so fast. There's a new case called Brunel out of the Supreme Court. We're going to talk about that. And that's one of the ones I said to pay attention to. Okay. So the other thing you got to understand is, what is 24(1) all about? Basically is to grant, often it's to grant a remedy in abuse of process cases, right? And there's 2 categories based on the distinction of the 2 different types of fairness. One is the fairness to the particular trial, the particular accused that you were dealing with in your case, okay? And the other one is the integrity of the justice system and the public interest, right? So those are called, quote unquote, the main category. So if your client's rights have been violated, section 8 to 14, you can look at this, okay? Even section 7, but section 7 really pretty much deals with the residual category, which is the system and the public interest, okay? Those are things to remember. Now, again, this is where it's a little bit confusing, right? So you have to look at the effect of the charter breach. You have to look at the effect on your client. And, even if it's residual, the system, right? That is the basis for your argument. That doesn't mean that your client has standing, okay? And we're going to get to that in a second. I'm just bringing it to your attention now, so when I'm talking about this, you can think about that. So the Brunel decision that I talked about, that's very important, addresses standing in the cases of abusive process when it affects the integrity of the justice system, AKA the residual category. Basically, this is the deal. There's 30 people, they're all arrested. It's a large-scale drug operation, drug trafficking, right? They're divided into 4 groups, 4 separate trials. And then some of the people pled out, and then some of the people challenged it. And the issue becomes, and what the court decided is that the police had systematically violated all the rights guaranteed by Section 8 and 10B of the Charter. Okay. And more specifically, they argued that the police had deliberately delayed the right to retain counsel without delay. They had the accused collectively requested a stay of proceedings, the ones that hadn't pled out. It's kind of like doing treaties with Donald Trump. Don't sign a treaty now, hang in there, fight it. Okay. And then what happened is the court decided that it was an abuse process that undermined the integrity of the system and therefore fell into the residual category. So they found, I'm not sure this is the right terminology, but they found the cause of action under 24(1). Okay. So that says that there's been a systemic abuse under the residual category. But then what the court does is this is a really important part. Basically, this is the broader analysis of 24(1), the cause of action, as you will. That's my version, my words, not the court's words. But because it undermines the integrity of the justice system, the question becomes, is it a violation of individuals' rights or fairness in their specific trial? So you have to make a nexus between the abuse to the system and your client, okay? So the one thing, I don't know if I wrote this in the list, if I can just have one moment. I did not. So on Brunel, under paragraph 50 to 54, they talk about the fairness in connecting your client's specific charter violation to the group and the abuse of the system. Okay. It's a little bit complicated, but it's not when you read Brunel 4 times. You'll figure it out. Next, you can get costs and damages under 24(1) as a charter remedy. As we talked about before, you have to go to KB or a court of competent jurisdiction for damages, but for costs, you can do it through the province, although some provincial judges will give you kickback on that. I can also indicate too that again, here we go, boring. The court needs jurisdiction over the person, over the subject matter, and over the remedy. The problem is the remedy here, okay? And the other thing is too, is if you're going for money in KB, there has to be a loss. That's an old tort thing, and it's still under 24(1). And again, you can bring this in addition to 24(1). And then this is the kicker. Remember the language under 24(1)? Appropriate and just. Well, it's not a unicorn, but it seems to be northern lights that turn red you see every 10 to 11 years. Good luck with that. If you look at the case law, the discretionary power is very broad, right? But it's the old Canadian thing, right? We had like even 24(1) and 24(2). It's like, oh, your rights are violated, but yeah, we got to see if we're going to keep it out or we're going to, put you back to where you were. that's what the whole purpose is with the the limitation on the damages is appropriate and just. Drives me a little crazy, as you can tell.
At some point, are you gonna allow us any questions?
Sure, of course. Let me see. I noticed we're a little bit shorter on time, so let me focus a little bit more on some of the other important things I had. The other thing is too, is to get money as costs or as damages. If you look at the case law, you basically need misconduct of the Crown. The other thing is the cases say police misconduct is not misconduct of the Crown. Oh, yeah, I know. Sean, you're looking at me. I know exactly what you're thinking. It should be. The other thing is too, is that if you don't have misconduct, you're definitely going to have difficulties. I can tell you that there's the Crown misconduct they did find to recompensate for was for disclosure. And I can tell you that it was a situation where it has to be something where the Crown's aware of it. That it can't be just negligence, or it has to be almost intentional. Okay. If not, it does have to be intentional. Okay. The other thing is they had something called financial hardship, but it's extreme financial hardship. Sure. And again, for that, you have to prove the marked departure from the standards, which is very difficult. Also, there's ones where like the Crown was warned they should make disclosure and they still didn't do it. So those are cases that you might see come up. There's also for Crown misconduct, they did a big operation and they knew there was going to be a lot of arrests, like 50, 60, 100 arrests. And they didn't make sure there was bail hearing judges and Crowns available, so people sat in jail. So they said that was misconduct. But even then, even though you got the misconduct, you got it, it's got to be appropriate and just, right?
Mm.
I should also indicate that there's really an analysis there. I'll kind of go through it really quickly with you, but first there has to be a flagrant case, an intentional case, or failure to respect the person's right and the disclosure. Okay, specifically, these come up on disclosure. The evidence has to be important. In this one case that I cited to you, basically, it was the second most important thing that corroborated the Crown's case. In this one case, there has to be a proof of the damages, right? So the court costs. In this one case that I cited to you, and I'm trying to think of the name of it, but anyways, there's 5 days of proceedings on voir dires or motions filed by defense counsel, and the Court of Appeal awarded $20,000 in costs. The other thing is too, is if you're doing a disclosure case, like all disclosure issues, the court looks at the Crown's, the defense's conduct. So if you got a case where you're missing disclosure, every 2-3 weeks, if you think of it, send an email to the Crown. Where are we at on this? Where does this stand? Keep in mind when you're emailing, you don't want to be too loosey-goosey because, well, I am, but you don't want to be too, because a judge is probably maybe reading your emails later as to, you making the request for disclosure. So that's important. And the other thing is, obviously, the defense lawyer has to do their due diligence, especially with issues of disclosure. But it's a heavy burden. And how many times do we have issues with disclosure? How many times have you ever heard of a 24-1 application being filed or being successful? It's not that common. The extreme financial difficulty I just mentioned, there's an Ontario case called Tiffin. They use words like rare, unique, and what have you. There's got to be something to extreme hardship on the defendant. And that it's got to be an absent Crown misconduct will not be appropriate and just. So they come right out and say, appropriate and just. Well, yeah, it's not only a limit, it's a bar. Okay. And the cases are rare, so if you find them, fantastic. So when we get to the costs as well, let's just talk about that for a second. So you get the costs for a civil claim, right? If you're going to do this at KB, you don't do what I do. You contact management and you get coverage on your certificate for it, because I forgot one, as Catherine knows, and I should have known better. But you get a 525, which is new. You get one of these McNeil applications, which are going to come down the pipe with these officers. You get these 24-1. You want to make sure that you have coverage for it. 24-2 is pretty much standard in every drug case. I think legal aid considers that. If you spend too much time, you can always ask for a DI, but it's really part of the trial process too, right? 24-1 may or may not be part of the trial process. So you want to make sure that you do administratively the right things. This is coming from a guy that sometimes doesn't, and that's why I'm saying that, because I know. The other thing is the FurCan case. I think I listed that for you. Anyways, long story short, in FurCan, I did list it. It goes through the analysis of appropriate and just, but it also goes through what's considered as far as the costs that should be paid. And they look at the nature of the case, the legal complexity, which is pretty much like legal aid, length of proceedings, nature and extent of the misconduct of the prosecutor, and then the rights that are impacted, and then the conduct or lack of conduct by third parties. Let's just go to the next thing I want to touch base on, and that is you can if your client's rights have been violated, you can apply for a reduced sentence under 24-1, theoretically. Okay, let me explain that. So basically, prior to this case, the other case that I said was really important, that I mispronounced, NASO GALUAK. Nasogaluk. I hope I get that right. Anyway, so up to that point, if you had the living hell beat out of you and they strip searched you and then they searched your apartment without a reason or a warrant, they would take that into account under the sentencing principles, 718. And you could ask for a lesser sentence. Okay. And then there's the Mills case, which I didn't cite, but you'll find it when you read those other cases. And basically in the Mills case, it says, it talks about considering these violations. Well, then we have the charter, and now it's a charter violation, 24-1. So there have been applications to apply 24-1 to reduce the sentence, as well as 718. For some reason, that's one area where I've used it and been successful, but I didn't really read the case law because the Supreme Court says that's kind of a bad idea. They don't like it. They want to apply 718. But the one thing they don't address in their questions are, okay, so you want to apply 718, it's a bad idea. Why do we even have 24-1 then in relation to this? And that's something that Parliament should have considered and really should be put to the Supreme Court. Anyways, what am I saying to you? I'm saying to you that if your client has his charter rights violated, you could make an application under 718 and you could make an application under 24-1 to cover yourself and cover your client and ask for a reduced sentence. Now, are you going to win under 24-1? I'm thinking, looking at the case law, probably not, even though it seems like it should apply, because the Supreme Court says it doesn't really. Well, they didn't come out and say that. I'll get to that in a second. But the thing is this, when you file a 24-1 when you file a 24-1 motion, you get people's attention. And the judge will be looking at that going, oh, I don't see those very often. That's a unicorn. Oh, no, it's a
unicorn.
Okay. So you might want to do that as a strategic thing. Again, probably have to talk to management, but I know. So just think of this as 24-1. I'm getting close to the end of time. 24-1 will give you a range of different remedies that 24-2 will not. Okay? 24-2 is your meat and potatoes, bread and butter section. 24-1 is the arcane art of defense law. Keep that in mind. So the thing is, and I'm going to get to this because I only have 5 minutes left here. But getting back to the Supreme Court and their belief under whether 24-1 applies to sentence, the accused in Nozogalak, there was a high-speed chase. He resisted arrest. He was drunk. He was dragged out of his vehicle. The police punched him in the head twice. And then he resisted some more. So they basically beat the hell out of him. It doesn't really say that in there, but he had punctured lungs. So
Oh, well.
go figure that one out. Right. So the Supreme Court looked at this and they are trying to decide the conflicting law prior to this case. Okay. And they said that basically they were, 718 addresses these issues. They don't really say why 24-1 is kind of not engaged. Justice LaBelle said that, and he said for the court that the guarantees of the charter require that the sentence be appropriate to the circumstance of the crime and the offender. Wait, that's 718, right? And that enshrined in section 12 of the charter, take into account the facts of several and real violations of the offender's rights, providing that they bear the necessary connection to the sentencing exercise. So again, it's 718. What is he talking about? So that's important to know. But since that time, and I got 3 minutes, since that time, there's been some other rulings come out, and I think I include those. Yes, Eau Claire out of Quebec tells about exceptional circumstances when there can be a stay after a lack of disclosure, okay, which is important to note. And there are the other cases. There's one other case, if I might just have one moment. There's some cases that are interesting too, where they say there's one case where they reduced the sentence, but it was below the mandatory minimum, and they didn't bring a motion in reference to Constitution Act, like I'd already discussed, and because of that, they failed because the law wasn't attacked, just the sentence was. So that's a good example, and that was Donnelly and Gowdy out of Ontario. But there was another case, as well as the Quebec case, Eau Claire. I can't think of it now, to be honest with you. It's Sebaston, Sabiston from Saskatchewan. I have that on there as well. And it says basically charter violations should be considered on sentencing. The other thing to be aware of, if you have a structured undercover operation where you got wiretaps, you got Mr. Big, you have multiple people, there's case law on that where 24-1 does apply about having perhaps even a stay. There's been stays. So that is kind of the big exception to the toughness of 24-1 and trying to apply it. Sorry, I'm going to stop for Marcel. She's got a question on.
Very, very quick. 10B, right to counsel. You would think in a large case, where there's multiple accused and all the police actions taken in the case, that they would need to inform the client absolutely right away your right to counsel, because it's such a big operation.
So they didn't, in that case, they didn't make any provisions for it. It was just kind of like Casablanca, round up the usual suspects. And yeah, they had a problem. They didn't account for that.
Huh.
So like if they have a major project, they should be thinking about what they're doing in bail court.
They should have a strategy in place right away.
And the other thing is if your client's being put over 2-3 days, You want to know why on the record. Our new system is such that there are now these other courts. I don't like them. I keep saying, give me a real court and a real judge, which makes me very popular. But the reality is get in front of a real judge, put it on the record. And why you're done, and then you can bring your action. I'd make sure I'm on the record though. Not with the JGP, but with the judge.
Thank you.
Okay, well, I'm gonna talk about 24-2.
Give me 1 sec. I'm going to share a screen for a PowerPoint presentation. 1 sec here. Well, how do I make this?
I tried to make it lighthearted and fun, yeah.
I know, I like the sunflower motif
Can someone online just confirm if you can see?
Looks like
the
honeycomb,
PowerPoint?
actually.
or honeycomb.
The theme is honeycomb.
Yeah, okay.
Not very artistic.
Yes.
You were on.
like that. Okay. Down. Side to side, side to side. Yes. Right, so I'm gonna present on 24-2. I wanted to just talk very quickly about the charter because I didn't know if Kevin was going to. So obviously we know that the charter protects basic rights and freedoms that are essential in keeping Canada a free and democratic society. And I bring that up because obviously, you know, in our current times, that's something that we took for granted and maybe we should consider a little bit more. So if an individual thinks that the government has put limits on individual rights without good reason, the court challenge may be brought forward. And if the court agrees with the individual who's brought the claim, the court may order a remedy. The charter sets out 3 types of remedies. So Kevin's talked about one of them, 24-1. I'm going to talk about 24-2. This is a picture, obviously, of the signing of the Constitution Act, which brought in the charter. And I just thought it was funny because the Queen looks kind of bad while everyone's cheering around her.
Only the one on the right is the only one that's alive now. The rest have passed.
Okay, so the wording of 24-2 is where in proceedings under subsection 1, a court concludes that evidence was obtained in a manner that infringed or denied any rights or freedoms guaranteed by the charter. The evidence shall be excluded if it is established, having regard to all of the circumstances, that the admission of it in the proceedings would bring the administration of justice into disrepute. So we're going to go through what that means, but just temporally, there happened to be a CBC article that came out recently that I saw the quote was, this is about sexual violence victims, and this individual who is the advocate for the Fed said, the harm is so well recognized that police officers and Crown attorneys regularly caution survivors against reporting or pursuing the charges. The administration of justice is in open disrepute. So maybe the system is already in disrepute.
Are they exaggerated?
So 24-2 is engaged, obviously, once a charter protected right has been found to be violated. So once that happens, initially the burden is on the accused to establish that the right has been violated. But once that happens, then the burden shifts to the Crown, and the standard of proof is a balance of probabilities that the Crown must demonstrate that the evidence being admissible would not bring the administration into disrepute. The purpose of 24-2 is to maintain the good repute of the administration of justice. Section 24-2 looks at whether the overall repute of the justice system viewed in the long term will be adversely affected by the admission of evidence. This inquiry is an objective one, which asks whether a reasonable person, informed of all of the relevant circumstances and values underlying the charter, would conclude that the admission of the evidence would bring the administration into disrepute. And so I put up this slide to talk about, the focus of the remedy of 24-2 being long-term. And essentially, the court has said that the section is not aimed at the impact of state misconduct on a particular criminal trial. So the intention of 24-2 to find the evidence inadmissible is not really to punish the police, to say, you did a bad job, and it's not to provide compensation to the accused. But broadly, the question is whether or not, after a breach, admitting that evidence would bring the administration into disrepute in the long term.
Geez, that's sad.
So the leading case on Section 24-2 is the Queen versus Grant from 2009. And I thought that I would just go through, I know we talk about the Grant test, which people know about, and I will go over that, but I just wanted to remind everybody about the facts in the Queen versus Grant. So his name was Donahue Grant. He was 18 years old. He just turned 18. That's why it's the Queen versus Grant and not the Queen versus G. So basically what happens in this case is there's a seized gun during a police encounter on a Toronto sidewalk. And the charter sections that were breached in this case were Section 9, so the right not to be arbitrarily detained, and Section 10, the right to counsel. The case actually happened, this incident happened with the police November 17th, 2003, so just over 22 years ago. But the context for what happened in this case is that there were 4 schools in the area of Greenwood and Danforth in Toronto that had a history of student assaults, robberies, and drug offenses during the lunch hour. And so there were 3 officers that were on patrol to maintain a safe student environment. 2 of the officers were plainclothed officers, and they were driving an unmarked police car. And then there was 1 uniformed officer, and he was driving a marked police car. So Mr. Grant was a young Black man walking down the street. The 2 officers in the unmarked car testified that he stared at them in an unusually intense manner and fidgeted with his coat and pants in a manner that was suspicious. So the officers decided maybe we should have a chat with this guy and see what's up with him. That was their direct testimony. They communicated with the uniformed officer that he should have a chat. And so the police officer said, "What's going on?" and requested Mr. Grant's name and address. In response to that, Mr. Grant provided his provincial health card, and the police testified that he behaved nervously and adjusted his jacket, prompting the officer to ask him to keep his hands in front of him. It was at that point that the other 2 officers pulled up just to stand by and make sure everything was okay. And they approached and identified themselves as police officers because these were the plainclothed officers. They flashed their badges, but then stood behind the uniformed officer, so essentially obstructing the way forward for Mr. Grant. And the exchange between the officers was as follows. "Have you ever been arrested before?" Mr. Grant says, "I got into trouble about 3 years ago." Officers, "Do you have anything on you that you shouldn't?" "No." "Well, I got a small bag of weed."
Uh-oh.
Question, "Where is it?" Answer, "It's in my pocket." Question, "Is that it?" Answer, male puts his head down. "Yeah, well, no." Question, "Do you have other drugs on you?" "No, I just have the weed, that's it." Question, "Well, what is it that you have?" Answer, "I have a firearm." So Mr. Grant is then arrested, searched, and marijuana and a firearm is seized. It's at that point that he's advised of his right to counsel and taken to the police station. So what happens in Grant at the trial level is that Mr. Grant alleges breaches of Section 8, Section 9, and Section 10B. And the trial judge says that the inquiries didn't amount to a search and that he was not detained prior to his arrest. And if he was, that he had waived his rights by cooperating with the police officers. The firearm was admitted, he was convicted, and it turned out it was also a revolver, which if you went to the gun lunch and learn, you would know is a restricted firearm, so not good. The Court of Appeal said that yes, there was a detention during the conversation before he made the incriminating statements, There was no reasonable ground to detain him, and the Court of Appeal did find a breach of Section 9. They didn't deal with Section 10B. They found no Section 8 search issues. And then when they got to the 24-2 analysis, they found that the firearm was derivative evidence, which means, that evidence came from his self-incriminatory statement, and would often be excluded on that basis, because the old test from Collins applied. So we'll talk about that in a second. But they looked at the case and they determined that the admission of the gun would not unduly undermine trial fairness, and that the repute of the administration of justice would be more damaged by excluding the gun than by its admission. So then Grant went to the Supreme Court. The Supreme Court found, yes, he was arbitrarily detained, Section 9 violation, and his Section B right to counsel was infringed. All right, so then the court moved on to the actual 24-2 analysis. And the 24-2 analysis happens in 2 stages. So you'll have to get past the threshold stage before we can move on to the evaluative stage, which is what we commonly know as like the Grant test is the evaluative stage. But I'm going to talk about the threshold stage for a moment. So the threshold stage, to pass this stage requires that the evidence was obtained in a manner that infringed the charter. So the charter breaching conduct must be part of the same transaction or course of conduct. And essentially most cases do have sort of a pretty clear path between the breach and the evidence that's being targeted for exclusion. And normally the threshold issue is pretty easy to get past, but not all the time. And so I'm going to talk a little bit about situations where you can't get past the obtained in the manner. And just for the case law, the question of obtained in the manner was discussed in the Queen versus Terrans. A strict nexus isn't necessary. In Strachan, the court said, treating the obtained in a manner requirement as an exacting threshold would be contrary to the remedial scheme of 24-2, because it would foreclose trial judges from engaging in the core inquiry that's needed to preserve the repute of the administration of justice, and potentially prevent trial courts from having an available remedy for charter violations that should not be condoned. So there is a situation, though, in which something called the fresh start doctrine applies. And so the leading case on this is the Queen versus, do we call it, if it's past tense, do we call it the Queen? If the Queen was still alive, do we have to know when they died? R versus Beaver, 2022. Evidence will not be obtained in a manner that infringed the charter right if police conduct after the initial charter violation effectively severs or renders too remote or tenuous any temporal, contextual, or causal connection between the violation and the evidence that's obtained. And so your question might be, Jane, can you give me an example of what that would look like? So I'm going to tell you a little bit about the case of Beaver. So Beaver is a case from Calgary, Alberta. And essentially there were 3 individuals who shared a townhouse. The deceased, there's someone who dies in this case. The deceased father owned the townhouse, and the other 2 roommates were there paying rent. Okay, so the other 2 roommates were Beaver and a guy named Lambert, and they were tenants. One morning, one of the roommates calls 911 and he says, one of my roommates is dead in a pool of blood. Told the 911 operator, I don't know how he died, but there have been some altercations with the roommates throughout the week. The police arrive on scene and detain both Lambert and Beaver. They sort of caution them and they bring them to the police station. When this case went all the way up to the Supreme Court, and I'll just say that it wasn't disputed that at the time that the initial officers came on scene and arrested them, that they were arbitrarily detained. There wasn't enough evidence just in the 911 call saying, hey, I live with this person and they're dead. The court found, and the Crown conceded that that was an arbitrary detention. Anyway, so the homicide detectives then come in and they realize, whoa, like these guys were unlawfully detained because they know what they're doing a little bit more. And so what they try to do is they try to make a fresh start by advising them of their charter rights. And they actually arrest them for murder at that time. So they give them their notice of arrest for murder. There, in the in-between intervening time, there's been some more information that was gathered so that the detectives were able to make that arrest. So that was not arbitrary. They had reasonable and probable grounds. So they try to make a fresh start by advising them of their charter rights, and eventually both of these individuals, Lambert and Beaver, confessed to killing their roommate. And so the question for the court here was the issue of admissibility of the confession. And this is an interesting case to read because the court was not unanimous in their decision. The court found that their confessions were voluntary. So aside from 24-2, the Crown still needs to prove that any statement is voluntary. But what the court says in Beaver is that obviously evidence can still be excluded if it is obtained in a manner that infringed a charter right. So basically the question for this case was, what does a fresh start look like? And so what the court says is when undertaking the case-specific factual inquiry into whether the police effected a fresh start, there are some potentially illustrative indicators that include one, whether the police informed the accused of the charter breach and dispelled its effect with appropriate language. Two, the police cautioned the accused after the charter breach, but before the impugned evidence was obtained. The accused had a chance to consult counsel after the charter breach, but before the impugned evidence was obtained. That the accused gave informed consent to the taking of the impugned evidence after the charter breach. That the accused was released from detention after the charter breach, but before the impugned evidence was obtained, and whether and how different police officers interacted with the accused after the charter breach, but before the impugned evidence was obtained. So as I said, so it was agreed that there was the charter breach. The Crown, though, argued that there was a fresh start. So they said, yeah, maybe the arresting officers messed up and didn't, inform them of their rights. But then when the detectives that knew what they were doing came into the room, they said, hey, like, you're under arrest for murder. You have the right to counsel. The case with Beaver, it's Beaver and Lambert. And it's interesting because what happens with Lambert is that the detectives come in and very clearly explain to him, you're under arrest for murder. You don't have to talk to us. It's actually probably not a good idea to talk to us until you've talked to a lawyer, et cetera, et cetera. And they really clarify like what his rights are. And he's still like, no, I think I'm going to talk to you anyway. So with Lambert, they were like, okay, the fresh start doctrine does apply. The evidence was not obtained in a manner that breached his rights. However, for Mr. Beaver, basically what happens is that the detectives that are interviewing him, they refer back to the police officer's earlier caution during his unlawful detention when Beaver was told that he was being investigatively detained for, quote, whatever is going on in the townhouse where the deceased was found. And also by saying to Beaver that it's no different than what Constable Husband told you before. So in that case, the detective, invoked this caution that, really wasn't, he really didn't get his full caution and rights to understand, what he was on charge for. And so essentially, they said, listen, that's not a fresh start. You breached his rights. And then they go through the evaluative stage And they say, that's okay, though. We'll admit the statement. So that's what you'll see, that 24-2 is a challenge. And I was just looking through the last 2 years of Manitoba case law. And I think out of the, and say maybe 16 cases, only 2 of them had evidence that was actually not admitted. Okay, so the next step is the evaluative stage, aka the grant test. And there are 3 portions to the grant test. The first question to ask is that what is the seriousness of the charter infringing state conduct? And whether the admission, so the question is, would the admission of evidence send a message that the justice system condones serious state misconduct? The next question is, what is the impact of the breach on the charter protected interest of the accused? Because the admission of the evidence may send the message that individual rights don't really count for anything. And the last question that needs to be asked is, what is society's interest in adjudicating the case on its merits? And I went to our helpful page criminal law notebook, and they had this little diagram. So the first 2 prongs of the test favor the exclusion of the evidence, whereas the third portion does favor the inclusion. All right, we have a hand raised. I can, yes. Andrew,
You may
yeah.
cover this. Yeah, you may cover this in a minute, but where does the importance and or the amount of weight to the impugned evidence fall in that discussion? Like the old, saying, if what's a drug search without a charge challenge, guilty plea? It's like, the drugs are out no matter what. How much does that weigh into things?
How much does, sorry, can you repeat the question?
How much does the weight of the impugned evidence to the case, right? So
Right,
is the
yes.
impugned evidence critical to, like, if it's the gun we're talking about and the gun's gone and there goes the case, versus, well, the impugned evidence is a comment about something versus, like the physical evidence versus so where will that fit in this, if you don't mind telling the crowd?
Yeah, so that will fit into the society's interest in adjudicating the case on its merits, because and I will get to that in a second. But essentially, the questions to ask is like, how reliable is the evidence, and what is the importance to the Crown's case? If that evidence is excluded, do they have a case to make, right? So, I mean, the question is, how do we figure out whether or not the evidence should be included or excluded? The judge has to balance it. And in all cases, it's a task that the trial judge has to weigh the various indications, and there's no rule, there's no sort of mathematical equation in terms of whether or not the judge should include or exclude. But I'll go through those 3 sections as well. And just let you know that previously, before the grant test in Collins, the question of whether or not evidence should be excluded was considered under the following factors. Number 1, whether the evidence will undermine the fairness of the trial by effectively conscripting the accused against himself. Number 2, the seriousness of the charter breach. And number 3, the effect of excluding the evidence on the long-term repute of the administration of justice, where Justice Lammer acknowledged that these categories were, quote, merely a matter of personal preference, but then quickly became formalized as the test. So then Grant jumps in. And I actually do think that Grant, in a way, is a more favorable decision for the state, because the test in Collins was basically that if evidence was non-discoverable conscriptive evidence, it would automatically be excluded. Mm-hmm. So in the case of Grant, the only reason that they found that he had a gun was because he made these incriminating statements. So that gun wouldn't have been discoverable but for him being detained, speaking with the police. And yeah, so in terms of what is conscriptive evidence, the accused, in violation of his charter rights, is compelled to incriminate himself at the behest of the state by means of a statement, the use of the body or the production of bodily samples. And so the court in Grant basically said, well, we really need to consider in all of the circumstances, and there's some circumstances where even if it is non-discoverable conscriptive evidence, we still want the opportunity to be able to weigh in as to whether or not that evidence should be admitted. And so that's why I think that the test in Collins was more favorable for the accused, because if it was non-discoverable conscriptive evidence, it was automatically out. And the Supreme Court said in Grant, it's difficult to reconcile trial fairness as a multifaceted and contextual concept with the near automatic presumption that the admission of a broad class of evidence will render a trial unfair regardless of the circumstances in which it was obtained. So it was time for a new test, and we went through the test. How much time do I have left?
6, 4 minutes.
4 minutes. Okay.
It's okay to go over.
Yeah.
So the first question for the test, whoops, I don't want you to know what happened. And so under the seriousness of the charter infringing state conduct, basically the question is, what did the state do? And in these cases, it's going to be mostly what is the conduct of the police? Did the officer try his best? Did he know that he was breaking the law? So, obviously the more egregious the conduct, the more that it favors the exclusion of the evidence. And I would note that officer credibility is obviously very important when it comes to this prong. And that's why, I was a little bit surprised actually to find out that in Manitoba, at least, oftentimes the Crown attorneys will provide a list of questions to the police in advance. I think for charter applications, that's maybe a little bit sketchy, given that credibility is such a big issue there. But anyway, I digress. The impacts of the breach on the charter protected interest of the accused, this inquiry focuses on the seriousness of the impact, and it calls for an evaluation of the extent to which the breach actually undermined the interests and the protected right infringed. So, the impact of a breach may range from something fleeting and technical to something very profound and very intrusive. And so the more serious the impact on the accused protected interest, the greater risk that the admission would signal to the public, that individual rights aren't important. So in Grant, the court says to determine the seriousness of the infringement from this perspective, we look to the interests engaged by the infringed right and examine the degree to which the violation impacted those interests. For example, interests engaged in the case of a statement to the authorities obtained in breach of the charter include the Section 7 right to silence, or to choose whether or not to speak to authorities, all stemming from the principle against self-incrimination. The more serious the incursion on these interests, the greater risk the admission of evidence would bring the administration of justice into disrepute. And then finally, the question is society's interest in adjudicating the case on the merits. What you'll look at there is the reliability of the evidence. Obviously, in the case of Grant, the evidence was a gun, and it was pretty reliable in that it was a gun. If it had been, trying to think of a situation where it would be less, I guess in the case of if it's a statement and the statement is taken without, giving your right to counsel, then maybe the reliability of that statement is not strong as physical evidence. And then as the question was asked, what is the importance of that evidence to the Crown's case? That will factor into it, of course. And to some extent, the seriousness of the offense has some importance. But ultimately, as we're saying previously, the question of 24-2 really has to do with broadly, will this evidence being admitted affect the whole system, looking forward in terms of whether or not the public thinks that the system, makes sense. So those are the factors to be considered. And in conclusion, Mr. Grant's gun was admitted, and the court in that case said that the police conduct was not egregious. They said they weren't racially profiling him. They said they were just chatting with him. And the impact of the charter breach they did find was significant, although not at the most serious end of the scale, but they found the value of the evidence is considerable. The system will not be found in disrepute if it's admitted. And I think from Grant sort of onwards, at least I've been practicing law for about 6 years, and everyone always said to me, if you have a gun, it's going to get admitted. And I'm getting a thumbs up from Andrew. But I don't think that that's what happened in Grant, but I don't think
Actually, that's not true. That's not true. I had a gun excluded by Menzies a few years ago.
Okay.
A handgun. Yeah. A
Who
really bad
excluded
handgun.
it? Who excluded it?
Menzies.
Menzies. Man, well, of course it was Menzies. Who cares? He didn't care.
Well, no, Menzies has a brain and guts, right? There you go. By the law.
And then, but Block, I just had 2 years ago with Miles. I had one in Winnipeg, and Justice Block actually found the breach, agreed with us completely. But yep, too bad it's a gun. He goes in. So
You always lose on
actually,
24-2. Yeah.
absolutely.
I was going to say something to everybody too. Like, if you look at
Sorry.
Beaver.
Wait,
if-
let her finish. Kevin, I
She
interrupted.
is
Let her
finished.
finish.
I thought she was.
She
That was
not. She was concluding.
Oh, no, she's not
Now I
finished.
was
Never
going
mind.
to do my musical portion of
Exactly. Let's have the musical.
Read the Beaver decision she went through. It is very disturbing.
Oh.
And if you believe in statements, in England, they got rid of statements and they didn't convict people because they tortured basically the Irish. Apparently, we're politer and nicer here. Sleep deprivation doesn't count, which is something that is very
Waterboarding.
affected at, which is, like Americans and Israelis have perfected it as torture. Basically, you will do anything to sleep. And the fact is, it's a cost-saving measure where they get a good conviction in their mind. And this Beaver, the reset button is just outrageous. You need to read the case. You really need to read that case. It's scary.
So where does psychological detention come into these charter violations? Because
Well, that was Grant, wasn't it? Like Grant
Yeah.
was the psychological detention
Grant.
case that sort of, yeah.
So that, and like, as it applies to the analysis, that the psychological detention, right, is part of the section 9, like he was arbitrarily detained. So in the conclusion, the court said, that is a significant breach, the fact that he was psychologically detained, but not on the most serious end. I mean, obviously they didn't pin him in the corner and, say you can't move, but.
But I have a huge problem with that case because the officers, the second set of officers, the detectives, they come and they tie their warning to the first guy's warning. So
Beaver, we're
it's
talking
like,
Grant,
what?
wasn't it?
Yeah,
Was that Grant too?
I was talking about
Beaver.
Beaver, we're
Grant.
talking about Beaver. So
talking about Grant.
I was answering his question
Yeah.
as it related to
Sorry.
the detention in Grant,
Yeah,
but we'll
sorry.
go back to Beaver.
Anyways,
Back to
read
Beaver.
the case.
I'm not in the room. I should leave. I got to go to a meeting anyways, guys. Good to see a great presentation, Kevin. Looking fantastic as always.
Thanks, Andrew.
and Jane.
And Jane, no, sir. Well, I
thought you were done with
thank
it.
you, Jane.
Yeah.
I don't know Jane as well, so I don't want to comment on anything. I can make fun of Kevin because I've known him so long.
Yeah.
But, Jane,
no
very well
problem.
done.
Read Beaver.
All right. Beaver.
Okay, well, we can leave with the idea that Beaver is very important.
One last thing, did Kevin mention the constitutional questions?
Yeah, I did. Twice, I think. But don't miss it. File the, if you think you have a law that's violating the charter, you need to file that as well as your 24-1. I think I mentioned that.
52-1, you said.
So yeah, section 52, I believe. Yeah.
You said that at the beginning.
Does anybody have any questions? If you're online, feel free to unmute yourself and just speak up. Let me just check the chat very quick.
I have a question, Kevin.
I'm out of answers.
24-1 question.
Sure.
Hey, so I had a case, drug case.
Right?
I went 7, 8, 9, 10A, 10B, and grabbed all breaches on all those. All 3 points of the test went to exclusion. Evidence excluded. Crown didn't stay, just didn't say anything. Acquittal. So it was an acquittal, not a stay. So it's an acquittal. During the trial itself, she admitted during it that the jacket was hers, that the ID that was seized was hers, the $300 cash was hers, admitted everything. During the voir dire, she admitted everything except the drugs that wasn't asked, but there's a record, besides the fact that they seized this from her person, right? So after this happens on the 29th of July, I said, yeah, no, they have to return your items now, the legal items. They might give you problems with cash, but I don't see any, I haven't been served any civil forfeiture or anything, so they have no right to hold it. So the ID should come back, the cell phone should come back, the jacket should come back, the two purses should come back, everything that they said was hers and they seized should all come back. She goes down there to RCMP, say, no, we're not giving this to you. And so I emailed the federal crown, top Mercier and Sarah McNamara. I say, hey, they're not giving her stuff back. It's an acquittal. There was no forfeiture in any of this, right? They're just keeping the drugs because it's illegal. You never get your drugs back. There's no forfeiture of nothing. Crown gets back to me and says, we've talked to the RCMP, and the RCMP's position is this. Because the disposition sheet that they received didn't say give her back those items and was silent on that issue, we're not giving those items back.
Perfect. You got that in an email?
What's that?
You have that in an email?
From federal crown? Yes, but they also said, as a measure, what we could do is we could bring the disposition, we can bring this back on or ask the court office to alter the disposition sheet to have their items returned. Court office and Porter's chimes in, the one in charge of that stuff, on the same thread, and says, no, that's not the way this works. The way this works is the RCMP need to return the items because the disposition sheet doesn't say forfeiture. And then the federal crown chimes in and says, you have our position on the matter. And that's it. Then this is in July, right? So I think July, August, September. So I think I'm up to September now, maybe August or September. She goes down again. And this time I send her with a support person who I said, take notes, email me right when you get back. Because they're going to say no to her, but I want you as the witness to detail what they said. She goes down there. They give her a cell phone from another incident where I got her charges stayed, like nothing to do with this one. They tell her they're not getting anything back from that one. And there's an argument that ensues. She backs off. It's all written up. So they refuse. Okay. So then what month are we in? We're in November. Okay. So then in October, I get Sherry Moffat, who's the trial coordinator, runs the court basically in Portage. She calls over while I'm in the room to the officer in charge of the detachments. I want the officer in charge. These items from March 27th, blah, blah, list them out. They must be returned to Miss Bearable. They say, okay. Miss Bearable goes down there. No, we're not giving those items to you. So then this is where it gets really interesting. Sherry Moffat called on Friday, gets a different officer in charge, Corporal Perry, who says, the only thing we have is the cash. We didn't seize. We don't have those clothes. We don't have the cell phone. We don't have the personal ID. All we have is the cash, and we're not giving it because it was part of a drug investigation.
And there's a prisoner log?
There's a prisoner log. It's in the disclosure. It's all seized from her.
Okay.
Item seized from her. Item seized from blah, 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 blah. So I'm like, at this point, and she's like, just go. I'm not going to, all right, I was going to say, she's all in. She'll go all in on this. I don't care. Right. Like I want, like they violated my rights once and to the point where 3 ounces of meth got thrown out. And now they're just pissy because they lost. So they're just trying to be, difficult about it. And so I need some help about how to proceed on this. And I thought 24-1 looks like a good shot, but I don't know how to.
Like the problem is you need to go to KB, first of all.
Yeah.
Because you need, you need to get the money back or the equivalent thereof to make her whole, right? So that's more of a tort.
But at this point, isn't my position that, like, this is just coming from Sherry Moffat talking to them. Isn't my position at this point with my client is that they just haven't returned the items. So can I not do a 24-1 to ask the provincial judge to order them to return the items?
Mandamus?
Just return the items, right? Like, that's all I want. And like
The charge is gone though, right? Like they're no longer, the judge doesn't have jurisdiction anymore.
can I request it?
That would be a civil claim, wouldn't it?
Yeah, that's why I said you gotta go to KB.
But there's no way to do a requisition to bring it back on the docket?
he's funked us, right? The case is over.
It would be fun.
There's no jurisdiction. So my thing would be is to send something to the RCMP right away, make a complaint to Ottawa, fuck them. And tell them that you're bringing a civil suit. And you're, and then and I talked to legal aid about getting authorization.
Well, I need that before I do. I need to get a legal aid cert.
Yeah, but I would sue them. And then I'd invite all the reporters. That's what I would do.
So my action,
I don't know, but
the action is going to be through KB, right?
Pardon me? Yeah, you gotta go through KB.
And it's got to be a civil.
Yep. Because I don't see, because the criminal matters are over, right? So anything under 24-1, like I said to you before, it has to be part of the criminal case. You have to have jurisdiction over the matter, blah, 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 blah. If you don't have the charges are gone. I think that you're out of luck on that. I think it's a civil matter now. Like if you did that before they didn't stay the charges. She was acquitted, right?
Yeah, she's acquitted.
See, I think that hurts you more because like if they stayed the charges, then you could say they can bring the charges back within whatever, right? Like a Crown can always bring the charges back once they stay them, right?
Yeah.
There's the abuse of process and double jeopardy, all that stuff. But theoretically they can do that, right? So you could fire 24-1 and say, hey, we want the stuff, and they'll say no jurisdiction, the judge is functus, and you could argue, well, they stayed it, they can still bring it back. But if she's acquitted, and you're past the appeal period too. So I think you gotta go civil, unless I'm missing something.
Okay.
I don't,
Just noticing section 490 of the code too.
what?
Look at 490
I
of the
did.
code. You did it.
Yeah, it's report to justice, right?
Yeah.
So what they should have done is what they're going to try and say is that, oh, if she comes and proves this stuff is hers, but she didn't have to prove that stuff was hers. They said it was hers. Like
Right.
they seized it from her.
Put them on the stand.
Yeah.
Put them under oath.
No, and here's the kicker. There was no report to justice for the initial seizure of all the items. And I didn't discover that till later, but because I was looking for the report to justice once I realized they weren't returning the items, and there is none. So they didn't even do any report to justice to start with.
I think it'd be fun to put them on the stand. If you need somebody to cross-examine, call me.
No, don't worry.
That'd be fun.
Those
Are you?
Gospel Gill has enough for me.
Yeah.
He's the one, yeah. He's the one who found negative inferences and everything. So, but he's also the one who should have returned the items. He's the only officer involved. So he's really just making more problems for himself now.
I would just take a strip off him and then at the end I'd go, this is a personal thing, right? Right? This is personal. You're upset because you violated her rights and the charge was stayed against you. Isn't that what this is about? And then he goes, no. And then you go, oh, so it's a systemic thing.
I like it.
How does he answer that?
Yeah. And like that. I just.
Yeah, let the RCMP know you're suing their ass. There you go.
Okay. Well, I guess
It's-
coverage for.
And plus, I think to sue them, you have to probably make a complaint, but I have to look at that. I haven't looked at that in a long
I
time.
think the other
You know
thing,
who sues them all the time? Sometimes well and sometimes not well is Ian Hystad.
I think Carl has too. He had one in Portage,
Yeah.
right?
is there, like, so there's no way to. Because at this point, it's not, it's about suing them. It's about getting a judge to make an order to return the items.
Right, so like he said, that's a mandamus. Right?
Okay, and that's in KB too,
Yeah,
because you need a provincial court. The judge doesn't have the authority to do that.
I'd sue him for both. Fuck him.
You'd hope that if you get an acquittal, the judge also orders to get the stuff back. Sometimes they don't.
Yeah. I mean, like that's come up before with me too, where it's been really hard for my clients to get their stuff
Yeah,
back from.
but it sounds, this is way beyond that. Like in Winnipeg, we have systemic bureaucratic baloney. But this sounds like more than that.
Yeah, she had 7 sets of charges and nothing happened to any of them. So they're pissed.
Well,
Yeah.
let him answer to Ottawa.
Yeah, because it's unfair to have their stuff taken and then you're free to go, but we're keeping your stuff. The fuck?
Yeah.
Well, CID is, she wants to do her guys, but come on, you're telling me she has to prove that that photo ID is her? Get out of here.
You know what? Put them on the stand. Put them on the stand.
Okay.
And if the Crown doesn't call them or whatever, ask the court to call them. That's what I would do. That's how I'd handle that actually. Now you just brought it up, so I haven't really thought it through, but in this case, I would I'd file a motion asking that the court call the officers as witnesses.
But this is through a mandamus, you mean, or through what?
Yeah.
Like, what's the originating process, I guess? Yeah, I guess it's.
Yeah, I think you'd bring a civil action with damages, tort, and mandamus is how I'd handle it. Because I want the shit back, and if you don't give it to me, then I want money paying for it. And I want court costs.
Can you, in a civil suit, ask just for like property that's unlawfully in someone else's possession to be returned? That's
Sure.
right?
Sure. It's called family court. Oh, sorry, never mind. Yeah, it's that you can.
I'm gonna need some help with this, so you maybe get an email from me, needs me in more detail.
Yeah, it's been 100 years since I've done civil work, but and I'll joke you aside, the family lawyers are probably right on top of that.
The family lawyers?
Absolutely. How many times does somebody own something that the other spouse has taken out of spite and won't give it back and blah, blah, blah. Right?
Yes. Well, thank you for,
I just think it's horrible that happened, and it's almost tricky. Like, why wouldn't you just stay the charge instead of waiting for an acquittal?
oh, why didn't the Crown? Yeah, I'll save my comments on what happened there.
So, but I'm just saying,
Yeah.
it seems odd, right?
I don't think they know what to do at that point.
All right.
Okay, well, thanks very much to both Kevin and Jane. We really appreciate your imparting your knowledge onto us today. If anybody has any follow-up questions, you can feel free to email me or Kevin and Jane directly. And we will try to put a copy of this Lunch and Learn session on the homepage, Lunch and Learn video page. Okay, have a good day, everyone.
Thank you, Catherine.
Thanks.
Oh, so you're still recording? I should have said fuck them.
Yeah, I was like, maybe
I think I short.
edit that.
I don't care.
Maybe a short.
I'm from the Catherine Dallas School. I don't care.
Hey, funny.
So, yeah, I might have to email you about that.
Yeah,
I need to do something. I need to do something. But
Yeah.
how
Well-
can I be able to get coverage for this though? Like
Well,
that's
first of all, I think you got to figure out what you can do civilly. And then second of all, I think you need to file a complaint with the Ottawa ASAP.
Ottawa, or do you mean like the RCMPD division when you go online and it says you have a complaint about the RCMP?